Hey, everybody. Welcome to Thursday night. Hey, everybody. John Skiba here from the Consumer Warrior YouTube channel. Welcome to Thursday night, where each and every week we do a live Q&A where I'm an attorney in the state of Arizona, and we talk about all things debt related. I do bankruptcy practice. I also represent people who are getting sued by creditors, like junk debt buyers, credit card companies, all that kind of stuff. And so we do this live Q&A. If you're on YouTube, I'm broadcasting this live to both Facebook, Twitter, and YouTube. But if you're on the YouTube feed, you're going to be able to go to the chat section. You can put questions in there. I'll put them up on the screen and we'll talk about them, which leads to the weekly disclaimer, because what would I be as far as an attorney if I didn't have a disclaimer? The disclaimer is I can't give you legal advice. You shouldn't interpret anything I'm giving here as legal advice, particularly because I'm only licensed in the state of Arizona. And I know many of you are from all over the country. I don't know the laws there. If you need legal advice, you need to talk to an attorney in your particular state. If you live in the state of Arizona, you can contact me. My contact information is below, and I do free consultations where I can walk you through whether it's bankruptcy or debt defense or whatever it is. I can help you out. The rest of you need to take this for what it is. This is some dude on Facebook, Twitter, and YouTube talking about just chatting. So it is what it is. But so go ahead and put the questions in there, and we will get to those. One thing I wanted to start off with tonight, something that we talked about both in a video I put out on the channel, as well as I talked about on the live stream, is Al, thank you for showing up each and every week. I appreciate it. Is Prop 209 here in Arizona. So this was a proposition on the ballot a few weeks ago. It passed by a huge amount. And it changed the exemption laws and the way that garnishments and debt collection happen in the state significantly. Right now, the homestead exemption protects $250,000 of equity. This new thing jumped up to $400,000. It protects against bank levies or bank garnishments. It used to be $300 protected. Now $5,000 is protected. Wage garnishment. I was at a creditors attorney symposium recently, and one of the creditors attorneys there had the opinion that this law would impact 70 to 80% of wage garnishments going forward, because it reduces it down to 10%. Right now in Arizona, they can take 25% of your check if they do the garnishment. So all these things it impacts bankruptcy practice. However, it is going to be something that's a little bit complicated. I can tell you that there are lawsuits that have already been filed against to try to stop this or try to get some clarification on it. So it's not going to be as clear cut as we were hoping. I do think overall it's a big benefit and will help people in the long run. But there's going to be the way that the statute was written, it's going to be interesting to see how it plays out in the bankruptcy courts and in litigation and garnishments and all that. So early on, I think that the courts will give some guidance pretty quickly on this, but so I just wanted to give you a quick update on that. It did pass, but it's going to be, I know the bankruptcy attorneys I'm talking to were all kind of being a little bit cautious at the time being. So, all right, let's jump into some of the questions. Early on here, we got Quick Strike came in. Said, hello, Mr. Skiba, I have for you. Says, got a bank garnishment letter on Monday. However, they have the wrong garnishee. I don't have an active account with that bank. Should I schedule a hearing anyway? So the garnishee, in a wage garnishment setting, the garnishee is the employer or the bank. It's the entity that the creditor wants to give them money or to intercept the money from you. And so what I'm taking here from what you're saying is the bank garnishment. So they served it on a bank, maybe where you don't have an account. So typically, I can tell you, at least in Arizona, what they have to do, the garnishee, when they get served with the writ of garnishment, they have to, search their records and see if the person who's on that judgment or who's on that writ, if they actually have an account there. And then they have to fill out an answer and file it with the court. They have to let the court know if you actually have an account there. So if you're in Arizona, I would probably wait and see if the bank, the garnishee, if they file their answer with the court and let them know that you don't have an account there. before I'd go down to the hassle and all that of a hearing. If you're not in Arizona, I don't know the procedures. So you may want to talk to an attorney in your particular state. But the bank or the garnishee, they're going to have to respond, particularly if you don't have a bank there, because Arizona has a very unique statute. If the garnishee just ignores it, if they just blow it off, the creditor can actually try to make them liable for the judgment. I've seen it happen where banks end up paying a judgment because they completely just blew it off. So I would, you could even reach out, I guess, to the bank and see if they're going to file their answer and see if that squares it away for you. The follow-up, you said you're disabled. Something else that, if your income is Social Security disability, that's something that you're going to want to look at as well. You could raise the objection if it's like Social Security in there, that those funds are protected. That may be a reason to request a hearing, but you may want to just wait and see because they're going to have to file it fairly quick. Because the creditor wants to know if they've got the wrong place. And it kind of brings up another side point. Usually with those garnishments, it's kind of a fishing expedition where they're throwing that garnishment out there. They don't know if you have an account there. They don't know if there's any money in there. They don't know if the money is exempt. So it is something where you could request in a hearing and raise an objection if the funds are exempt, something like that. So, all right, Alex, hey man, thank you for each and every week for being here. Let's see what Alex has to say. Does ADOR, the Arizona Department of Revenue, or the IRS have to get a judgment against you to garnish your wages or levy your bank account? Support from Yuma, Arizona, all the way in Yuma. Yuma is actually a long ways away from Phoenix. If you've never been to Arizona, Yuma is right down on the U.S.-Mexican border. And gosh, it probably takes 3.5 hours to get down there from here. It's quite a ways. Everybody goes through Yuma on their way to San Diego. So the IRS does not. So they can send out a notice of levy and they can garnish your wages and they can levy your bank accounts without having to sue you and actually get a judgment against you. They fall under what's called the golden rule. He with all the gold makes all the rules. The IRS has all the gold. They're the government. They make the rules. They don't. The state of Arizona, though, typically does. The Arizona Department of Revenue will sue you, get a judgment before they're going to do any type of wage garnishment or bank levy. I don't see the state of Arizona being as aggressive on that as the IRS. I do see them filing lawsuits. And they're usually doing that to spur you into getting some type of payment plan in place or getting something taken care of. You don't want to just ignore that. You don't want to ignore the IRS. You don't want to ignore the state of Arizona. Bad things will happen. So that's something to be really aware of. All right, let's go back to, I saw this J phone had a question here. Said, hey, I'm at the end of my arbitration motion. Let's see here. After 2 months, how do I go about asking for dismissal with prejudice? So with debt collection lawsuits, particularly those by junk debt buyers where the original creditor had an arbitration clause, you have the option of asking the court to dismiss the case and allow the parties to go through private arbitration to resolve the dispute. Now, a lot of courts, instead of dismissing the case, they will enter an order staying the litigation for 60 days, 90 days to allow the parties to initiate litigation. Now, a couple of strategies. One, you as the defendant could go and initiate the arbitration. Like I said, it's always procedurally a little weird to me because if you're initiating the arbitration and you don't have any claims against the plaintiff, the creditor, why, it'd be like going to a court and filing a lawsuit against yourself or filing a lawsuit against the collector when you're not asserting any specific claims against them. So I have also taken the position that you could file a motion to compel. The court gives you 60 days. And then if they don't pursue it, come in and file a motion to dismiss with prejudice, saying, Judge, this is their claim. They wanted to pursue it. I'm not going to go file a lawsuit against myself. And if you look at the arbitration clause, some of the arbitration clauses actually require the creditor to be the ones who initiate it. So basically you're saying, hey, I'm electing the forum, but you've got to be the one to initiate it. And so I think that's the argument that you can take. You want to go back and look at that arbitration clause in the terms and conditions for the original creditor and see what it is specifically that it says. But yeah, if you're getting close to the end of the 2 months, I would file something to get this in front of the judge. Randall, thank you for reaching out here. You got some, says you're going to send t-shirts. Randall has sent me t-shirts. He sent me t-shirts for my entire family. My kids, I have my daughters at home. These are often like the night shirts, part of the pajama outfit. They've all got these law t-shirts on. So Randall, thank you very much for that. This one, J-Phone, going back to that question, says, by the way, so far so good against OneMain and an official lawyer. It seems not even a junk debt buyer. They've been very active against my motions, but the compelled arbitration worked thus far. And that's because it throws a wrench like into their system I've talked about. The collection firms, they handle gigantic volume. And it's usually a handful of attorneys or less, and they've just got a lot of volume, very automated type system. So doing that does cause some issues for them as far as just procedurally getting it done. All right, Daniel says, hi, what if someone files for a second Chapter 7 2 months before the 8-year deadline? Please advise. So if you're filing a Chapter 7 bankruptcy, you file a bankruptcy and you receive a discharge, you have to wait 8 years before you can file another Chapter 7. And it's 8 years from the time that you filed the first Chapter 7 before you're eligible to get a discharge in the second Chapter 7 bankruptcy. So that's the first thing you need to understand is if the first Chapter 7 bankruptcy was dismissed or for whatever reason you did not receive a discharge, then nothing. Then you could go forward with a new Chapter 7, even within the 8-year period, you're going to be fine. However, my guess is that if you're saying, hey, I filed a Chapter 7 bankruptcy, it was successfully discharged by the court, got rid of all the debts. Then if you file another Chapter 7 bankruptcy before the 8-year deadline has expired, you're not eligible to receive another Chapter 7 discharge. So it could be something, if you have an attorney, you need to talk to him. I mean, that's an issue. You don't want to do that typically because, I mean, the whole point of the Chapter 7 is to get the discharge. It could be something where you could seek to dismiss the case and then refile it in 2 months. However, in a Chapter 7, you don't have this automatic right to dismiss, and the trustee or a creditor could come in and object to it. So yeah, because the Chapter 7 is not going to do you a whole lot of good if you're not able to get the discharge. You know, there's really often not any real reason to do that, to file a bankruptcy, unless you can get that discharge order, which eliminates all the debts. So, all right, let's see here. Triple Crown says, hello, I'll be claiming bankruptcy in January. In the meantime, I've just begun being emailed, texted by collectors. Should I ignore them or tell them that I'm headed for bankruptcy? There's not really a big any benefit. If you tell them that you're filing for bankruptcy, they're not going to stop the collections. They're going to ask, okay, do you have a case number? Do you have an attorney? They're going to want to know those kind of things so that they stay in compliance of the bankruptcy laws, as well as some of the FDCPA laws, the Fair Debt Collection laws. And not only that, I've talked about this before. A lot of people say, oh, I'm going to get a better settlement if I tell them I'm just going to file for bankruptcy. Everybody tells them they're going to file for bankruptcy. So there's a little bit of cry wolf there. They're going to say, okay, just do it. But they're not going to stop anything until you give them a case number or you tell them you have an attorney that you're dealing with. So I don't think there's really any reason to reach out to them at this point. You don't want to mislead them. You don't want to say anything that's not true, but I would probably just say nothing at this point. So, all right, let's see here. See what James has to say. Out of the blue, I have a lawsuit delivered to my door by the sheriff, but in my original terms and conditions, it says notice and cure. I was never contacted of the debt and never offered to settle. The debt I didn't know about, not even on your credit. So what you're saying, if I'm getting this right, James, is you're saying, hey, you got this lawsuit served. They brought it by the door. But the terms and conditions say that they're supposed to provide you some type of notice. The fact that a lawsuit's been filed, you don't ever want to just ignore that. You don't want to just think, well, they didn't do what they were supposed to do, so I'm just going to blow this off. That's how you end up with the default judgment. And once a default if you're not responding to a lawsuit, that's how you end up with a default judgment. And those can be tough to unwind. So my recommendation, you could file a motion to dismiss if you feel that there's something in the original contract that says that they were supposed to engage with you or provide you a settlement. I can tell you that's rare. I haven't seen that a lot. They may have to provide you with like a notice of default, but unless this is some type of personal contract where they've had to give you some opportunity or default period to cure the default before they file the suit, your option would be to file an answer. And you're saying you already filed to the court, so that's something that's good to do. You could also file a motion to dismiss if you don't feel like they stuck to the actual contract. So all right. Quick Strike says, been told to send a letter to the law firm that I'm disabled and judgment proof and to cease and desist on the accounts that they're trying to collect. So what that will do, if you send them a letter, so under the Fair Debt Collection Practices Act, this assuming that this is like a debt collector or like a junk debt buyer, if you send them a letter that says cease and desist, and essentially, basically you're telling them you can only contact me in writing. That's a good way to stop phone calls and that kind of thing. And then letting them know that there's disability. They have some information on you already. But if you're able to provide them proof that, your only income is Social Security and that they can't touch that, they may make a business decision that they're not going to pursue it just because it's an uncollectible debt. There's no guarantee that means it's going to stop. I'd be very careful about providing too much information to any collector. I wouldn't provide bank account information, or if you are employed at all, employment information. I'd be real careful with that. So, all right, let's see here. Tiffany, let's see what Tiffany has to say. Judge gave us 30 days for arbitration. Plaintiff needs to pay, but not answering the phone or emails. Is there a motion I should do? It's 15 days, biting the nails. Got it. Getting nervous over this. And it's good that you're being proactive on it. Well, if the judge is giving you 30 days for arbitration and the plaintiff is not responding, again, me personally, I would probably file a motion to dismiss at the end of the 30 days. I can tell you this too. Attorneys, being the law practice, particularly litigation, it's just like this never-ending term paper. You've got these deadlines all day long. And so sometimes attorneys don't respond until it gets really close to the end. So it may be something that they will be aware of it. But I would also document, your efforts to try to contact them. And if they're not responding to you, that way, if you do need to file a motion to dismiss, excuse me, you can show the judge, hey, I made a lot of attempts to contact this person and they didn't do it. So that, they're not engaging with us. So that's something you can use to your benefit as well. All right, let's see here. Let's see what Karina has to say. What do I do if the law firm doesn't want to negotiate? I've called and they want my financial info and I haven't given them anything other than making them an offer and attempting to negotiate. Yeah, and you do see that, or they'll, particularly if you're just calling into the law firm, you're probably dealing with a paralegal or frankly just a debt collector who has very limited authority to settle. Usually the attorneys at the law firm, they have a lot more latitude, or at least they can run it directly by. So I always say, if you can get to the attorney, you're probably going to get a better deal. But if you're just talking to a collector in the firm, you're probably not going to get too great of a deal. They might be able to reduce it by 10% or something stupid like that. So what you have to be willing to do is you have to be willing to walk away from the deal. If you're trying to negotiate it and they're like just offering something that doesn't make any sense at all, then I would say, just don't settle. So the question is, at what stage is everything at? If it's at the stage where they already have a judgment, they're threatening to garnish your wages, or they've already gone through the litigation process, then it's a lot more urgent and you're going to probably have to settle for something maybe even that you're not comfortable with. But if it's something where they haven't filed a lawsuit, they have, they're just, it's damaging your credit, but nothing else, unless there's a reason you need to accelerate it, then you could just say, we'll just wait. And like I said, sometimes the best thing that could happen is you get a lawsuit filed and then you're dealing directly with the attorney. Like here in Arizona, the lawsuit gets filed in the justice court system and then they set a pretrial conference. Usually you're going to either be able to talk in person or on the phone finally with the attorney directly. And I can tell you the attorneys generally get much better deals than their paralegal people who have very little, settlement authority. So, all right, I think we'll wrap that up tonight. But hey, I appreciate everybody checking things out. I'm going to try to broadcast these through Twitter and LinkedIn going forward. So hopefully you can check us out there. But again, if there's any questions or if you're interested in the tutorials, we had a bunch of you respond to our Black Friday sale, which was awesome. So I appreciate that. But I pinned it on the YouTube. I pinned a link to my tutorials that I have, and I have a bunch more coming out here in 2023, which are going to be awesome. All right, let's take one more. I had one more jump in here from a high-end transportation. It says, what happens if you sell a trailer for $25,000 down and they take over the payments, and I still owe the bank $18,000, and I sign the title over so they can contact the bank, but he wired $25,000. That got crazy complicated really quick. Okay, it says, then he ran with the trailer and the bank said they would sue me. Okay, so it sounds like that they gave you 25 grand. They just said they're going to take over the payments, but then you still owe the bank money. You signed the title over. Now they took your trailer and they've skipped town, which is a bad situation. We see this with houses sometimes. We call them, at least here locally, we call them like wraps, where someone sells a house on contract. They transfer title or they do like a deed of trust over, but then the mortgage still stays in the original homeowner's name. It's dangerous, and that's kind of what you're seeing here. There's definitely some high risk here. If you're dealing with somebody who doesn't have the best intention, there's problems here with what's going on, because the fact is you're on the loan. And even if you've sold it and transfer title and all that, you're still on the loan, and the creditor's going to be able to come after you. So definitely want to find an attorney and see maybe what your options are. You may have some defenses you could bring to the lawsuit. But yeah, that's a tough situation. Definitely get some legal advice on that one altogether. So, all right, we're going to wrap this up for a Thursday night. Hey, you know what? I'm going to be doing more live streams, kind of a little bit different. I did one Monday with my oral argument that people had a lot of questions on. And you know what? One of my, I'll actually put this up. One of my questions that I thought was kind of funny. So I did oral argument at the Court of Appeals a number of years ago against Midland Funding. And I do a live stream where I walk through that. You can check that out on the channel. But someone posted this comment: have you won all your cases? No, I haven't. And if you're ever talking to an attorney and they tell you they've won all your cases, you should go somewhere else, because they're lying to you. There's anybody with any amount of experience, there's just a lot of variables in every single case that influence the outcome. So no, I haven't won all my cases, but we won that one. So if you want to go watch something, I think it's kind of interesting, kind of to go back and kind of pick through it a bit and see what the arguments are, particularly as to junk debt buyers. That was a really interesting case, and one that actually made it into those books right back there. It's actually cited in those are some National Consumer Law Center books that talk about and teach lawyers how to handle debt collection cases. That case was cited in there, so you can go back and kind of see behind the scenes and get some of my thoughts on why it ended the way it did. All right. With all that being said, we're going to check out for tonight. But hey, thanks for tuning in, and we'll catch you